Alright, we're going to begin Business Law, Chapter 1, the laws and their ethical foundation. During this chapter, we're going to talk about the laws in the legal system. In Section 2, we're going to discuss the different types of laws that we can have. In Section 3, we're going to talk about our ethical basis for our different types of laws. So taking a look at Section 1, we are going to be talking about the laws in the legal systems. The goals that we're going to have for this chapter, we're going to explain the different stages in the growth of law, so how the law was developed, how it was kind of started out in some of our more ancient times. We will describe the differences between common law and positive law and how those impact the law systems that we're using. And we will identify the origin of the U.S. legal system and how things sort of developed to make that come into place. Okay, so the first thing that we're going to talk about is what is law. Laws are enforceable rules of conduct in our society. We have laws because it's important to understand kind of right from wrong, so people can't just take whatever they want. There's different sorts of punishment, whether it be damages, jail time, whatever it may be. So the stages in the growth of law, any sort of society tends to go through the different growth of the legal system. So whether it was way back in the ancient times when our societies were first beginning to develop, or in the more recent times in the Roman and English law, which we'll kind of be reviewing a little bit more in this section. The first stage that we have for the growth of law would be that individuals are free to take revenge for the wrongs done to them. So if we think back to biblical times, that would be kind of our eye for an eye, hand for a hand type thing. So if someone does something wrong to you, you have the right to have revenge against them. Now there's reasons that you could have this and there's reasons that you would not. In general, you'd want to eventually move past this stage because your society would kind of stagnate if everyone would be having their hands cut off and they wouldn't be able to work anymore. So the next stage that we have after that is a leader acquires enough power to be able to force revenge-minded individuals to accept an award of goods or money instead. So instead of being able to cut someone's hand off if they do something wrong to you, you could be awarded cash or have the right to take something of theirs of equal value for what they did wrong to you. The next stage after that would be that the leader gives power to the system of the courts. So this is where we get into kind of our English law, which we'll be talking about in a little bit, when there's different juries and judges that will start to be able to take over the courts and determine what punishments are deserved for different individuals when they do something wrong. And the final stage we have is that the leader or central authority acts to prevent and punish the wrongs that provoke individuals to seek revenge. So now we're looking at kind of the preemptive strike, basically, is what you're looking at, that we're going to have laws in place. So instead of people having to always act with revenge and getting damages back to them, we can prevent those laws by having things in place. So if you do something wrong, you know what the punishment would be. You wouldn't have to go through the court system after you do a wrong to someone and eventually find out what the remedy would be. The next thing that we're going to talk about is the common law versus positive law. Common law are laws that are based off the current standards or customs. So thinking of kind of today's age, there's different customs that we have now that are different from what they were in the past. So just some recent things that we have as some examples. The marijuana laws that are kind of going into place. So there are different states around the United States that have decided that they're going to legalize marijuana. Where in the past it was legal everywhere, the current customs are that it's generally becoming more accepted for people to use it as a recreational drug and kind of moving forwards with that. Another example that is very popular in the news recently is the gay marriage bans. So gay marriage went through the court system. It's starting to become more of an accepted practice to allow gay or lesbian individuals to get married, and the laws are starting to reflect those times. So the Supreme Court recently ruled that gays and lesbians were allowed to get married, and those are kind of the current customs that we have. So common law would be the current customs that we are currently using. An example of the past where a current law may have had to have been adjusted was back in the medieval times, if someone was deemed to be a witch, and let's say the majority of people determined them to be a witch, they could burn them at a stake, and there wasn't really much that they could do about that. Now, today's age, it seems ridiculous that you could have someone being determined to be a witch and burn them for it, but the common law at that time was following the customs that they had in place. The next one that we have is the positive law. Positive law would be laws that are put in place by some sort of authority figure. So our kings would put things into place, and they get to set the different rules that we're going to follow. So we're going to have a checkpoint now. If you would pause the video and answer the following question in your journal, and then we'll move on to this next section when you're ready. All right, so the next step that we're going to be looking at is what is the origin of the U.S. legal system? And there's a lot of things that went into place to determine what the U.S. would use as their legal system. Most of what they have is following kind of what is called English common law. English common law is basically what was in place before the Revolutionary War happened. They kind of carried things over from the English when they brought it over to the United States. And there's some small differences that they would have, which we'll be discussing here in a little bit. Okay, so the first thing is English common law. English common law was decided by different kings or feudal barons, and they would act as judges within their own local area. So they would determine what the punishment would be, what would happen if, let's say, they do something wrong. Maybe you would have your hangings back then. Maybe they would have to give up land that they owned, different things like that. And there were different reasons why that was useful and why it wasn't. Now let's imagine if the laws in North Dakota were completely different from the laws that we had in Minnesota. Everything is still covered by, let's say, the king, so the president in this case, but the laws that we had were completely different, and the people who determined those laws were completely different. So let's say if someone wanted to, if we had the right-of-way laws. So if you go to a stop sign, in general, it's accepted that the person on the right side has the right-of-way. Now, if that was the case in North Dakota, everyone who was on the right side would get a turn first, would drive through the stop signs, and so on. But if you're looking at in Minnesota, if the right-of-way was the person on the left had the right-of-way, if you traveled to a different area, you could get into different accidents because people accept different things as the standard of law. So eventually, they had to move forwards from the basic starting points of having feudal barons or kings determine all of the disputes. Another issue was that they had a lot more on their plate than they were able to solve just by themselves. So the next step was that in around 1150, King Henry II decided to kind of improve that situation. He went through the process of having judges and juries put into place. The judges would kind of travel around and determine all of the different issues. So let's say two people had some sort of dispute. The judge would come into town. They would be able to have their dispute at that time, and he would issue some sort of damages, who's in the right, who's in the wrong, and what would happen to remedy that situation. Now, the issue that we ran into was that in different areas, there were different rules that tended to be followed. This is where if everyone in the area determined one thing, but the judge that came in came from a different area, so again, when we're talking about the Minnesota versus North Dakota right-of-way laws, if in the judge's kingdom, they basically decided that left was the right-of-way, but in the local area, right was the right-of-way, then you'd have an issue between the jury and the judges. Now, to kind of stop the issues, the judges no longer had complete control. They were able to have different juries come in, which would be people of your own peers. So let's say if you did something wrong, your jury would be able to be people of your age group, kind of things like that. So the jury was people from the local area where the judges tended to come from someplace outside of the area. The important thing to note for this is that we have what is called jurisdiction. Jurisdiction is when the king or the head judge still has the final rule of law, basically. So they still get the final decision. The juries can't change the entire law. They still have to follow what the jurisdiction is set by the king, by the queen, whatever it may have been. An example of this you can view in page 7 of your textbook. You can read through that if you want to. It kind of goes through, again, the right-of-way type situation that we talked about with Minnesota and North Dakota. So check that out on page 7 if you need to. Moving on, we have the advantages of the English common law. So the advantages of the English common law when compared to some of the other law systems that were used in the past was that there was a sense of uniformity. So everything was the same. We had our laws that were written into place. People were able to follow them. They understood right from wrong based on the laws that were in place. The next thing that we have is moving on to the equity. So the equity is the overall fairness that you would have for common law versus when we're talking about our positive law. So the common law, the fairness towards it was that everything was kind of set in place. Now there's always some issues that you would run into where it's not in the law. And everything isn't always fair in terms of damages as well. So an example of this could be, let's imagine that Tom Brady, who is the quarterback for the New England Patriots, he decides that he doesn't want to play for the Patriots anymore. Let's just say for this example, he's getting paid $5 million a year. Now the Patriots are expecting that he follows the law and agrees to the contract that he had with the team. So that $5 million is basically keeping it in place. Now let's fast forward a little bit and imagine that the Minnesota Vikings decide that they want to have Tom Brady on their team. Now if Tom Brady said, okay, I'm not going to work for the Patriots anymore, I'm going to go work for the Vikings, they're going to pay me $10 million. Now the issue that you run into is that the equity or the fairness right now would be that the damages that the Patriots could recover in this example would only be $5 million. Now the Vikings are paying him even more than that. Is this fair to the Patriots that they just lose one of their players to the Vikings? Probably not. And the way that you determine that isn't always with money. So what you're moving on to after that is that you can have what is called a chancellor. The chancellor was someone who was able to issue some sort of injunction. So in this case, Roger Goodell, who is the commissioner of the NFL, would be able to issue an injunction which says that Tom Brady cannot play for the Minnesota Vikings if he wants to play for the National Football League. Now, chancellors eventually evolved into what is called mediators, and they were allowed to issue injunctions. Injunctions are just when you do not allow something to happen. Or they can say that something else would have to happen. And an example of that would be is if you agreed with someone to construct your house, and they decide after 5 weeks of working on the project that they don't want to work on it anymore, and they just quit. Well, you've already paid them. You have an expectation that they were going to complete your house. So a judge or a jury would be able to say that they would have to carry out the contract and finish working within a reasonable amount. Okay, so we have another checkpoint now. So again, if you can pause the video and answer the question, and then we'll move on. All right, and the last thing that we're going to have is I would like for you to review the hot debate on page 4 in the textbook and be prepared to answer the 3 questions that we have listed in the book during lecture tomorrow.